Victims. A Code of Practice for Victims was published in 2005. The code points out the assistance that offenders should hope to access from the criminal justice system. That involves notifying minor offenders within 1 working day, and all other suspects within 5 days of work, when there is insufficient reason to prosecute an offender. Civil actions. There have also been instances in which a criminal lawsuit has been filed when the Crown Prosecution Service fails to prosecute. The burden of evidence in civil litigation is not as strong as in felony proceedings, although some of this litigation have prompted the Crown Prosecution Service to sue. In fact, in 1998, the relatives of the murdered black woman scientist Joan Francisco brought a criminal lawsuit for trespass against her ex-boyfriend. The families believed that the man had killed her. They were active with a criminal case. The police and Crown Prosecution Service checked the facts and noticed out there was a very specific blood check that they have not used in the first trial. When this procedure was used, it was found that there was a man's bloodstain on the woman's t-shirt. The CPS subsequently charged the guy with murder, and in 1999, 6 years after the crime, he was sentenced. Criticism of the CPS. Criticism has been created that the CPS is not quite able to pursue disciplinary measures. The results of the Public Accounts Committee backed this critique. This was recorded by the CPS in October 2006 in the Crown Prosecution Service. Successful usage of the court proceedings of the magistrates for 2004 was 0.5. It turned out that there were a considerable number of events, both prosecution and pretrial, which did not continue on the day. When the trial does not proceed, the defendant was more likely to blame. However, the CPS was liable for 38% of the incidents. This was either not expected to continue or dismissed proceedings on the day of the trial. The committee reported that errors cost the public more than £173 million. For this, 24 million lives are listed as being due to the CPS. The reaction of the CPS was to find out that the unsuccessful trial figure had fallen dramatically from 31% from July to September 2002 to 23% from January to March 2005. This also acknowledged that further development had been made during the time reviewed by the committee. The CPS has increased its efficiency since then. In fact, the incidence of discontinuation of cases has decreased significantly. For certain places, though, there were still issues. In March 2010, a study by the Crown Prosecution Service Inspectorate, Analysis of the Conduct of the CPS London 2009-10, found that the CPS in London did not always work well. The study points out that the practice of the Supreme Court was so frequently improperly organized and that this had negative consequences on the preparation and reporting of the trial. Through 2011-12, the Inspectorate noticed in its annual study that substantial improvements have been achieved in certain regions.